Good evening, everyone, and welcome to GAE's session of Right Said Night tonight. My name is Sharon Doe, and I'm a high school physics teacher in Augusta, Georgia. I also serve as the Vice President for the Georgia Association of Educators. I bring you greetings tonight from our President, Lisa Morgan, who is out of town, but you can see her face on the screen. She's still with us. Go ahead, Mike.
Oh, okay. All right, Sharon, let me start the screen share.
And while Mike is getting ready, our topic for tonight is the 10 most frequently asked questions. Here at GAE, we think it's very important that we keep our members informed, because when our members are informed, then they can make better decisions about their lives.
Okay. There we go. All right, frequently asked questions. I think there'll be probably more than 10, but that's all good. So we always want to start with a reminder of our protections as a benefit of membership. Under legal services, we offer the liability protection in the event that a member is sued in court. For example, a parent that is upset that their special needs child is not receiving a fair and appropriate public education. Those suits happen, but they are a very small fraction of the cases that come into legal services every year. The vast bulk of the cases that we take in are under the employment and certification defense. As you see there, unlike our competitors, GAE has no predetermined cap on the amount of legal fees and costs that we expend on behalf of a member. So you never know if you're going to be that individual who is going to need the protection that goes beyond the caps that are imposed by other organizations. Another thing that we do on occasion is we file affirmative lawsuits on behalf of members. And those cases can easily exceed $50,000, and sometimes they go into over $100,000 in federal court. And no one has that sort of money in their bank account. But that's a benefit of membership. And you probably all know that we are representing Katie Rinderly in federal court as she was fired for reading a book under a divisive concepts policy in Cobb County. And that you can follow it online. The case is moving along in discovery, so there's not a whole lot to report right now. So just a brief touch on our history. I like to share some thoughts on who we are and how did we get here. We're the product of, GAE is the product of a merger of two organizations that had their beginning and their origins after the Civil War. As you can see, the white organization was formed in 1866, and the all-Black organization, Georgia Teachers and Educators Association, was formed in 1878. And of course, our society was badly segregated, separate but equal for over 100 years until the 1970s. And the court case that brought us all together was Brown versus Board of Education, that reversed Plessy versus Ferguson. So that's the overview of GAE, and we're the product of a merger. And I just want to share some important GA history or historical resources. Two books. The first one there is about Dr. Horace Tate, who was GAE's first African-American executive director. And it is a marvelous book, talks all about how Dr. Tate was the youngest Black principal in Georgia in charge of an all-Black school in Griffin, Georgia, and all of the strategies that he employed during the years of Jim Crow so that the all-Black schools could have equal access to the resources, same resources that the white schools enjoyed. And there's some good information there also in that book about the merger and the vote that occurred in the years of 1969 and 70. And the second book, as you'll see, is also about the experiences of Ulysses Bias. He was a Black principal in the Jim Crow South, again, by the same author, Vanessa Siddle Walker. Also a very, very eye-opening look at the challenges that Black schools had. This particular story is all about the segregated Gainesville City schools in Gainesville, Georgia. And Dr. Bias showed how even though his school was segregated by race, his school was as good in terms of academic achievement as the white schools. And the book will explain how he was able to do that. And the last piece there that I share is again by Professor Siddle Walker about the organized resistance in Black educators' quest for school equality. Again, she takes it from the origin story of the GT&EA in 1878. That's GAE's founders, the GT&EA, and she brings it up through 1938. Brings it up in through that particular period, and again, showing how Black schools were thought of as sites of resistance to white supremacy, and also how they were sites of strategies that the civil rights lawyers like Thurgood Marshall would go to and look for plaintiffs to sue the states in order to attain equal status under the law. So I recommend those reading materials. So now we turn into a little bit of education laws, and I entitle this, How Did We Get Here in 2024? Vouchers and waivers and bans, oh my. I mean, it's just like the Wizard of Oz, lions and tigers and bears, oh my. Well, we have vouchers, waivers, and bans, oh my. And it's been, see on the next slide, a long story of the efforts to privatize public education in Georgia. That's the sort of the grand strategy for those who want to privatize public education. You can take a look. We've got a Charter Schools Act in 1998. We then move up into a Charter Systems Act in the 07 and 08 area. And we also see vouchers begin to rear their head here in Georgia, but they're pretty smart and slick about it. They won't call them vouchers, they'll call them special needs scholarships, right? Or a tax credit for a tax credit scholarship. So they're smart enough to use marketing privatization without using those words to privatize, using taxpayer money to go into the private school sector, and thus, of course, depriving the public school systems of needed and necessary school funding. And then we jump ahead to more recent times. In the early, 2022, we'll see in a minute, those who want to privatize public education through vouchers realized there was no evidence to support that vouchers increase student achievement. In fact, the data shows there is actually student instructional loss that occurs when a student goes from a public school to a private school. With that said, with no data to support that vouchers actually work to increase student achievement, they pivot to the culture wars and make public schools the site of culture wars. And we see, lo and behold, in Georgia, 2 years ago, we have the divisive concepts law that inhibits and suppresses the teaching the truth of history in Georgia. And a corollary, we see parental rights and parental choice laws and book banning laws also being signed into law here in 2022. The next year, 23, another culture war law was passed in Georgia banning gender affirming care for students. Professional Standards Commission also got into the act by banning references to DEI, diversity, equity, inclusion from its rules. So they jumped into the culture war game as well. And then recently, and this is the one that, is rather new in Georgia. So they adopted the Georgia Education Savings Authority, which is another voucher law, but this time they included that vouchers could be used to send students to private schools. So we're going to be taking a look at that, not tonight, but a group of lawyers are going to be taking a look at a legal challenge of that, as whether or not under the Georgia Constitution, can you use Georgia public taxpayer money to send a student to a religious school. So again, just want to touch on everything I just said. How did we get here? It's ideology over evidence. It's been demonstrated through the educational research that vouchers do not increase student achievement. And once that had been established, excuse me, those that want to privatize are now putting a lot of money and effort into the culture wars, talking about values and parents' rights and parental choice. And you can see the laws that we have been being subjected to here in Georgia. And I just want to plug the book that gets into all of this data, The Privateers, How Billionaires Created a Culture War and Sold Vouchers, by Josh Cohen. It's a brand new book. Professor Cohen is an educational research of the highest regard and the highest sophistication in the United States. He's been studying vouchers, whether they work, whether they don't work. He's firmly convinced there's no data to support vouchers. And even those that are pro vouchers are now also they don't know how to deal with the lack of data, so they're pivoting over to a new frontier and a new beachhead to privatize education by pivoting to culture wars. And I just recommend another book that just came out, The Big Lie About Race in America's Public Schools. And again, that's about the culture wars being played out in our public schools. And you can Google those books and pick them up and read them. They're very short. They're good reads, and it'll validate a lot of probably what you've been thinking is going on. But these books pull all of the resources together for you.
And Mike, I think it's important to let our members know too that with these vouchers, they're taking money away from public schools.
Correct.
That's to the detriment of the public education.
Right. So the voucher, the money goes to the private school or the religious school, and it sucks money away from the public system. And that's awful. They're underfunded. Public schools are underfunded to start with. So this only, compounds the lack of resources. Thanks for that.
So not only is there a lack of data to support this, there's also a lack of accountability that comes along with these bills that they're passed.
That's right. That's right. A lack of accountability. I don't have the statute up in front of me, but if nothing else, it's going to have to be amended for accountability measures, or repealed, hopefully repealed one day. So with that landscape, we're all, those are the culture wars and the vouchers and the waivers and everything. But we do have a lot of rights, both on an individual level and on a group level or on an associational level. And we're going to take a look at some of these through federal statutes, state statutes. The PSE passes rules. And I want to stress that the last bullet, your local board of education policies. Know them, study them. There are 3 models of educational delivery in Georgia. I think we are unique in America. A charter school system in which the school district, the school board has waived all education rights. A strategic waiver school system where your school board is allowed to pick and choose which of the education laws that you can waive. And then there is the traditional system where nothing is waived and everything is by the traditional laws, no waivers or none of that. And there are only 2 systems in Georgia that bought into the traditional model. All other districts, leaving 168 districts, are either a charter school system or a strategic waiver system. Now, as we go through some of the rights, you'll have to go to your local board policy manual, your local school district website, and look at what model you are. Are you a charter school system or are you a strategic waiver system? If you're a strategic waiver system, then you have to find the list of laws that your district has waived. Because a few of the laws that we're going to look at may have been waived. So with that, we'll move ahead. Now, here's a law that cannot be waived, I'll tell you right now. But it's a very, very important law. True or false, educators do not have the right to inspect and copy their personnel file maintained at the school and or the central office. That's false. And the reason that it's a very important right is for, many reasons. What I have learned over the years that educators have a sense of empowerment when they go to the front office at their school and ask to see their personnel file. And by the time the educator goes back to his or her classroom, the office gossip has already started. Ooh, Dr. Doe wants to see her personnel file. Why is that? Well, it's because this Dr. Doe is right. And it's one thing to have a right, but if you don't exercise the rights, then they're just going to gather dust on the shelves. So it's important that we exercise the rights that we do have. Another reason why it's important to inspect your file is there is no law that requires the district to tell you they're going to put something in your file. Mm-hmm. So I will say that it is rare that there is some sort of written documentation that's negative in your file that the principal or assistant principal did not tell you about, but it can happen. But it's important as an an empowerment, step of empowerment to use your rights because you have those rights. It's important to know that your personnel file has two locations, at the school and at the central office. So when you ask to see your file, make sure you ask for the school location and the central office. Keep in mind, under the law, if you go to your front office, the front office assistant can say, I'm busy right now. Can you come back tomorrow? Or can you come back Wednesday and we'll have it ready for you? That's legal. That there's nothing illegal about having you to come back at a reasonable time to review your file. You can take pictures of any document in your file, that's free, or if you wish to make copies, the district can charge you up to $0.10 a page. That's the law. The last thing I would say is don't panic. Don't panic if they say come back tomorrow. Again, that's legal, but it's important to exercise those rights, because if we don't exercise them, they just gather dust on the shelves. True or false? Next question. All schools must have a safety plan to help curb the growing incidence of violence in schools. I don't know how many of you knew that. Maybe you do. You all go through terrorist trainings, live shooter trainings, and all the rest of that. Well, all of those trainings and all of those plans are required by law to be on file with the district under this particular statute, 20-2-1185. So one thing you can do, either as an individual or even better through your local association, ask to see the safety plans of the schools that you work at. Of course, we're living in, awful times right now, and guns seem to be everywhere, and we need to be aware of what the safety plans are. Now, this particular law says the safety plan is to be based on input from staff. That means you folks on this call have a right to have input into the safety plan. That may not mean necessarily they'll take it up, implement your ideas, but you have a right to see it, you have a right to read it, and you have a right to have input into the safety plan. And again, I would work through your local association to do that. It's a timely topic to do so. How many calls have we been getting in the conversations that are going on in your schools right now? And students are afraid to come to school now, given what's happened in Winder. So there's some food for thought right there. The school safety plan, mandated by 20-2-1185. It is your right to review it, and it is your right to have input into the plan.
And like most schools have on-site safety teams made up of the people who work in the building.
Excellent, excellent.
In my building, it consists of teachers, custodial staff, and the nutrition staff.
Good. Well, that's good. That's good. I mean, I would say, like requesting your personnel file is an empowerment move. Requesting to see the safety plan is also an empowering move. It gives people confidence to go maybe to the school board and speak about school safeties and things that we can do that we may not be doing to increase student safety and mental health, both of staff and our students. True or false, all local boards must have an appeals process policy that allows tenured educators to appeal a summative performance rating of unsatisfactory or ineffective. True or false? Well, a few years ago, that would have been false, but that is true today because of GAE's lobbying efforts. All school boards have to have a policy that allows you to grieve or appeal, I should say, your annual summative rating. That was established as of July 1, 2021. They are required to be on file with the State Board of Education, and they should be on your school board website. And if they haven't, they are in non-compliance with that particular statute. I have a model policy that I can send you or your local association, even if your school board has this particular policy, an appeal policy on its books. Again, I recommend or suggest using the GA model policy to improve what the local board has on its books. I can tell you, sitting here, I have seen many of what the school boards have adopted as their appeal policy. It doesn't contain many of the features that GAE, as a professional association, as a union type organization, wants to see as due process for its members. So there's an additional bit of homework. Again, work through your local association. Look at their appeal policy. Ask me to send you what the GA model policy looks like, and then take it to your local Board of Education and ask them to amend it. You know, we're here to attract and retain educators, not punish educators. So providing a meaningful appeal process would help retain educators. True or false? Under Georgia's duty-free lunch law, the 30 minutes includes walking with your class to and from the lunchroom. Now, I will say that is a false statement. The duty-free lunch law is very specific. It says that all teachers in grades K through 5 are entitled to a period of no less than 30 minutes instruction free and free of administrative duties, and it does not include walking your class to and from the lunchroom. Now, remember what I said about waivers. This is the law. This is the first law in tonight's Rights at Night that can be waived. The previous laws that we went through, the Open Records Act, the appeals process, the school safety plan, those cannot be waived. This law can be waived. Now, this law was adopted in the 1990s because it was seriously needed. Under Georgia law, educators, teachers in elementary grades do not have a statutory right to a planning time. So up until this law was passed, it was 8 hours, no planning, and you had to be with the kids all day. So this law fulfilled a critical need to the daily life of elementary and kindergarten teachers. But you need to check to see whether or not your Board of Education has waived this law. I know of many school districts that have taken the, to me, outrageous step to waive this law. That needs to change. That needs to change. Always keep in mind what your local board has waived compliance with. They can reinstate it. But that takes political group action and group pressure on those elected school board members. My thing is, how dare they waive this particular law? And many districts have, just like many districts have waived class size limitations. That frees up. What that does, they don't have to hire more teachers. They just put more kids in the classroom. And I know I'm preaching to the choir, but what they have waived, your local board can reinstate. That takes political pressure. That takes group effort. That takes our local associations working with outside groups, your PTAs, PTOs, your local church groups, any other group that sees the value in lowering class size increases student achievement. So same thing with the duty-free lunch law. When it's implemented properly, the teacher gets a break and they feel better prepared for the afternoon instructional time. True or false? After clocking out for lunch, a paraprofessional may be required to eat their lunch in the cafeteria without compensation. This law cannot be waived. It is a federal law, the Fair Labor Standards Act. Now, this situation, having the para clock out, but then being told to go eat lunch in the cafeteria, is the same as directing her to work, because when you're being told to go eat lunch in the cafeteria, you're monitoring the students in the classroom, and that is time that you are actually working. And this was an actual case that came up years ago where the principal was playing the game with the para clock out, but forcing them to eat in the lunchroom. And it was our UniServe director at the time got it all taken care of. I provided the law to the UniServe director, and they blew the whistle on this practice and got the paraprofessional her back pay, and they ended that particular practice. I don't know what happened with the administrator, but you know, by gosh, that's an abuse of federal law, cheating a paraprofessional out of pay. Again, that is a law that cannot be waived.
That's why it's so important that people become a member of the Georgia Association of Educators, so they can be aware of what their rights are. Because when you don't know your rights, it's easy for someone else to manipulate you.
Correct, correct. And again, this one, the member called the UniServe director. The UniServe director called me. We got the law straight, and yeah, they were cheating her out of pay in violation, blatant violation of federal law. And we stopped that practice and got her back pay. Another law that cannot be waived, the Family and Medical Leave Act. True or false? A school employee. It can be a teacher or classified. It applies to all school employees. Caring for her migraines can be terminated for her 12-week absence from work. No, you cannot. If you are on FMLA, caring for your migraines is a serious health condition as defined under the Family and Medical Leave Act, then you cannot be fired for taking leave. It's stated in the law, and when you return from your leave, you must go back to the same job or a substantially similar job. Now, again, this is a real life example, and it involved a bus driver who had migraines, and I learned in this case, I don't suffer from migraines, but they are very, very debilitating. And the medicine that you take when you feel a migraine coming on, as I learned, is also debilitating. You really can't drive a school bus while you're taking this powerful medication. So the bus driver would call in the morning if she had a migraine coming on and say, I can't come to work. Or she would call in the before her afternoon route and said, I'm having a migraine and I can't perform my afternoon route. Well, and this bus driver member, she had filled out the FMLA paperwork as well, entitling her to intermittent leave. The Family and Medical Leave Act guarantees up to 12-week absence from work, but it can be intermittent. Before, during class, after class, or morning route or afternoon route. It doesn't have to all be taken in a block. So important what this bus driver knew. I didn't teach her to do this. Somebody taught her to do this, probably our UniServe director. She kept a spiral notebook of the day she called, the time she called, and who she told she was not reporting to work due to her migraine. That was powerful, powerful evidence that we presented to the school district, and there was just nothing that they could do because she was fired. They had to reinstate her. They had to reimburse her out-of-pocket medical expenses. They gave her old route back to her. And on top of that, they actually gave her a brand new school bus on top of all that. But the Family and Medical Leave Act is a good law. When you have the right facts, it is a fantastic, powerful law. And if you're a GAE member, we can help you through these problems as well. True or false? The local board must provide reasonable accommodations to the known physical or psychological disability of an employee. Again, teacher or classified applies to all employees. And examples would include arthritis, diabetes, or allergies. True or false? Well, that is a true statement. The Board of Education is required to provide reasonable accommodations for the known disability of an employee. So, for example, if you have arthritis, say in your knees, or you have arthritis in your feet, and as a teacher, you're required to stand up and move around the classroom. That's part of a required duty, but the law says a reasonable accommodation is to allow that teacher a certain period of time to be seated during in classroom instruction. Diabetes. School classrooms often have rules that you can't bring food into the classroom, no snacks. It's not clean. It makes the classroom harder to keep clean if there's snacks in the room. Well, this particular law, the Americans with Disabilities Act, which cannot be waived, says that you can bring in snacks because you have diabetes. If your sugar level's going down, you need that sustenance so that you can continue functioning. Allergies is another common disability. And a common accommodation would be allowing you to have a air purifier in the room. That seems common sense, But in each of these examples, I've experienced the pushback from administration. Either they don't know the law or they do know and they don't care. But through GAE, whether it's legal or our UNISERV directors, we can deliver the information to the district that, look, this is a federal law that you're dealing with. You really don't want to escalate this. We can resolve this at the local level without involving lawyers. And that's how these things are usually dealt with without having to really go, full-blown legal. We can get that information to the principal, and they back up pretty much all the time. It doesn't have to go much further than the school level. But if it has to go to the central office, we'll take it to the central office, the HR or the superintendent, until we get compliance with this law that cannot be waived. So we move into, so that's a bit about individual rights, I would say. Your FMLA, your Fair Labor Standards Act, your ADA, more tailored to the individual. But now I want to move into what we can do not only as individual rights, but what we can do as associations. And that gets into a discussion of our rights of free speech and our right of association. Free speech and association. You join GAE, and because you have become associated with this professional organization, you now have association rights by virtue of your membership, in addition to your right of free speech. Now, the strongest protections of your free speech and association rights come when you are speaking as a private citizen on a matter of public concern. So what that really means is when you're working at school and you're on the clock, you're not a private citizen for most, intents and purposes. So we aren't going to find many instances where you have rights of free speech when you're on the clock. And there are exceptions, and we'll get to those. But the bulk of your rights come when you, say, go to the school board and you're speaking in front of the local board of education about a matter of public concern. And so when you do that, say you want to talk about, my gosh, you waived the duty-free lunch law, or can we unwaive that? Can we amend the charter to reinstate duty-free lunch, or can we reinstate the class size that you waived years ago? Because our classes are overcrowded and the levels of achievement would be so much greater if we had smaller class sizes. So you can make those are matters of public concern. And when you speak, use these additional statuses. They will offer layers and layers of protection. My name is Mike McGonigal. I speak as a citizen, state of Georgia. I'm a taxpayer in Fulton County. I vote in Fulton County. I have nieces and nephews who attend Fulton County schools, and I'm here to talk about class size and the detrimental effects it's having on our students. So now that I've layered up my different statuses in addition to my employment status, I've got lots and lots of buffer and layers of anti-retaliation protection should I be retaliated against in my status as a school employee. Use your local association status. I am a member of the Atlanta Association of Educators or the Organization of DeKalb Educators. You're putting out that layer of protection is your status as an association member. And we have had cases where it has been known where our members have been singled out because of their membership. And we have pursued those through the courts and won legal victories on that basis of associational rights. So a couple other limitations. A public employee speech is not protected if, and this first one is one of those what were they thinking moments when the United States Supreme Court ruled, I believe it was in 2012, or maybe even a little bit earlier, that said if it is within your job duty, and I'll use the example of child abuse or child neglect, because you are all mandated child abuse reporters, if you report that abuse or neglect and you're retaliated against, the very conservative United States Supreme Court said you do not have a constitutional right of protection if you're retaliated against, because you're required to do it as part of your job duties. What that means in practice is that we look to the state constitution, and we look to other laws like the Georgia Whistleblower Act that prohibits, if you can't be retaliated against if you speak out on governmental waste or fraud. And there's one other indicia, but speaking out, we look to the Georgia Whistleblower Law. And we also have seen, we exploit, if you're a special needs teacher and you're advocating on behalf of your special needs students, we can use the disability law, the Americans with Disabilities Act, which does have anti-retaliation protections because you're advocating on behalf of disabled children. You're also under the IDEA, has anti-retaliation protections there as well. So we look to other laws to provide a claim against the district if you're retaliated against in the scope of your job duties. Also, if you're speaking out on private personnel matters, there have been cases brought by teachers who've been non-renewed or terminated, and in the facts, they allege that they were retaliated against because the conversation they had over their evaluation was really what triggered the firing. In the case I'm thinking of, the teacher had a heated conversation with her principal, and yes, believe it or not, she tore up her evaluation and threw it down on the principal's desk. Up to that point, no decision had been made whether or not to non-renew or terminate that teacher. Well, they've voted to terminate or non-renew that teacher, and the teacher filed a lawsuit saying, well, it's because they terminated me because I tore up my evaluation and, slammed it down on the principal's desk. Well, the court didn't have a hard time with that one. They said that's a personnel matter. That's not a matter of free speech. That's a private matter that the taxpaying citizens of the county wouldn't have an interest in your own evaluation. If it causes a disruption in the workplace, your speech may not be protected. I don't have time tonight to get into Atwater v. Tucker, but I will say that case involved a middle school teacher in Tifton, Georgia, who went on her Facebook page and posted extremely racist, derogatory comments about the Black Lives Matter movement and parade that was going on during the holiday season in Tifton. The school district disciplined her. She filed a First Amendment lawsuit and said, I was on my own time, on my own Facebook page, and Black Lives Matter is a matter of public concern. We grant all that, but it caused a disruption in the workplace. Can you imagine if you're a Black child or a student of color in Tifton, in Miss, her name is Tucker, in her class? You'd be terrified to go into her class if you're a student of color. And of course, the parents in the community were very upset. And so it caused a disruption, and she lost her case. So the final limitation on your free speech rights is you can't say anything that's unlawful or untrue. That's defamation. You can have an opinion. You can say the superintendent is doing a bad job. That's an opinion, but you cannot say something that's demonstrably untrue or false, like the superintendent has a criminal felony arrest record for selling, fentanyl to students in another county. Well, that would be an untrue statement, something false. That's not protected under the First Amendment. So here's what you can do. Either as an individual or as a group, as an association, you can write letters to the editor on a matter of public concern. Again, class size or waiving your duty-free lunch. You can engage in political activities and marches and rallies and protests. Seems like now's the time that everybody needs to be doing something. Don't have to go further than that, but somebody said at a convention not long ago, do something. You're entitled to do that, and you cannot be retaliated against if you do. You can attend fundraisers, donate to political campaigns. You can sign petitions, but be careful of read that petition and make sure it's broadly phrased. It doesn't contain anything that's false or defamatory. And again, you can go to your public school board meetings, and yeah, you can be critical of the policies, not the people. You want to inform, but not inflame. My class is overcrowded. We need help. We need more teachers. Let's lower the class size by unwaiving what you waived in your charter school agreement with the State Board of Education. Or I need the duty-free lunch law because it helps me perform better, deliver better instruction to the students. Let's unwaive the law that you waived a number of years ago. Cannot be retaliated against for that speech. Okay, protected. You participate in a weekend rally protesting police brutality. Is it protected? You better believe it is. We had a GA member who actually engaged in that activity on a weekend, and he was arrested. It was in the local news, and a month or so later, his principal brought this to his attention and said that is reflects poorly on the profession, reflects poorly on our school that you're getting arrested at this protest rally in downtown Atlanta. And he wrote him up in his TEKS, giving him whatever it was, like a 1 rating under professionalism. Well, the member came to us, and you never want to say a case is a slam dunk, but this one was. We warned the school district, this is unconstitutional. This was protected activity. This educator was on his own time. The principal had no authority to put a negative evaluation in his TEKS. They refused to budge. We filed a lawsuit in federal court. It settled in 30 days. Number 2, you post on your Facebook wall a local newspaper article favorable to a political candidate. Yeah, you can do that. you can't be retaliated against for saying which candidate you're for. Now, I do know some folks might not want to publicize it, but you have a constitutional right to say that you are for one candidate or the other. 3, you write a letter to a publication that is critical of the school board for one of its actions or ideas. Again, that is legal, as long as we're criticizing, not going in personal, but we're criticizing a district-wide policy and, and promoting a solution, a resolution. How are we going to deal with this? We need to, again, inform, not inflame, and there are no enemies. We all need, to come together to resolve and work together to provide solutions to these challenges and obstacles that are facing us in public education. For you're a transgender woman, you use the Ms. title and pronouns she, her, and you prefer that others, including your students, do so as well. That is protected. And the background of this is a school in one of our favorite states, Florida, where the school administrators were telling this transgender woman that she could not use those pronouns, and she could not include that her students address her as Ms. And she, her. Well, this member filed a federal lawsuit, and under the First Amendment, said the court ruled, and I'm going to read off the question before the court is whether the First Amendment permits the state, the government, to dictate how public school teachers refer to themselves, who you are, how you identify when communicating to students. And the court, quoting, "The answer is a thunderous no." So that's a vindication of the right to identify whatever gender you want to identify, and the government cannot compel you to do otherwise. That's your constitutional right. So 5, your principal instructs you not to discuss with students your personal opinion on political matters. So you've got a directive there. In a classroom discussion on racial issues in America, you tell your students that you have recently participated in a Black Lives Matter demonstration. This can be a little tricky because the educator was directed and instructed not to bring personal opinions on political matters into the classroom. There's an issue there of whether that's insubordination, right? You may not even, if the district focused on insubordination, you could lose that particular case, whether if you were disciplined on that basis, if you brought up a Black Lives Matter demonstration. I mean, I would hope it wouldn't get to that, but it can. Couple others, social media and I'll go through these quickly. So on the first day of school, you ask for your students' personal email address to contact them if they're having a problem in class. These are just common sense. No, you shouldn't do that because you're blurring the line between your status as a professional educator and overlapping into the personal realm. You don't want to do that. You should use the school district's email or whatever platform that you have to communicate with students and parents. Not a good idea to get into the personal email. So 2, you've heard a funny joke on the radio on the way to school one morning, and you decide to email it to your buddy from your work email account. No, stop. what I might think is funny may not be funny to the person I'm sending it to, or they might think it's funny, but guess what? Once I hit send, I lose control over it. So if I send a funny joke to Dr. Doe using the school email, Dr. Doe might want to forward that to 500 people. And so we don't want to do that. So just think ahead. People certainly don't get my sense of humor. And number two, I'm using the work school email for my own personal business. That's the other issue that's sort of embedded in this question. Only use the school district email for work, not your personal business. You maintain an X account where you discuss discipline proceedings brought to you by the school district. Nope, can't do it, not protected. You maintain a Facebook page where you discuss your views on the upcoming elections. Yes, you can. It's like the example before where you want to say you prefer one candidate in the presidential race over another. You can do that. It's like putting a yard sign in your yard or a bumper sticker on your car. Those are constitutionally protected rights of free speech, and you cannot be retaliated against. And the last one is you maintain a personal blog, and one of your coworkers posts a disparaging comment about one of your students. Well, what one educator told me what they would do, number one, they would remove that comment. Number two, they would unfriend the coworker from that. It would happen to be a Facebook page, or change the security settings might be an option. And then finally, they would report this disparaging comment to the principal ASAP, because as we all know, by the time you get to school the following morning, the principal might be standing at the front saying, Mike, I need to talk to you. Come here. There was something on your personal blog or your Facebook page last night. I want to talk to you about this. This stuff happens so fast that you're better off being proactive to lessen the sting of, not that you're going to be in trouble, but being proactive is going to serve you better than being called in by Principal Doe. You don't want to face Principal Doe. I know all about it. So we're going to talk about, frequently asked questions. I don't know how often we get contract questions. Even though it's really not that time of year when contracts are coming out, we still get them. So just a quick reminder here in Georgia, since we do not have collective bargaining rights, we do not have that right to negotiate as a group, as a collective. We are on our own, so to speak, with contracts of adhesion. They're offered on a take it or leave it basis. They're not negotiated. It means one side has all the power. It's really no different than, say, your AT&T bill, your cell phone. If you buy a cell phone, have you read that agreement? Do you understand it? No, it's one-sided. It's not negotiated. How about a deed? If you bought a home, that's pretty much one-sided. Purchased a car, they slide that contract across the table. The only thing they're really going to negotiate is price, but that's about it. But they write all the terms. Well, that's what a teacher contract is like. You all know that. It's governed mainly by state statute 20-2-211. And then we have common law concepts, which are very, very basic. They include offer, acceptance, consideration, and it must be a term of a definite duration, like 180 days. term of definite duration, offer acceptance. And here's a little bit more knowledge I just put in this afternoon. Some very exciting, groundbreaking work by this law professor, Dylan Penningroth, who is a law professor out at Berkeley Law School, UC Berkeley. And he traces contract law in this Law Review article, Penn Law Review, from the times of slavery through the civil rights era. And the point he's trying to make is that what we think of when we hear civil rights, our minds immediately go to the 1960s civil rights era. He is saying, well, in the Black community, we used everyday rights. Those were the civil rights, even in slave times. His great-great-great-grandfather, Professor Penningroth, his great-great-grandfather was a slave enslaved in Kentucky. But guess what? As a slave, he owned a rowboat. He had property rights in that rowboat, and nobody was going to take it from him. And if they tried, he'd be able to take them to court. And yes, as strange as it sounds, there are cases of enslaved people going to court over property law. Here's the other remarkable thing about this enslaved man, this ancestor of Professor Penningroth. He not only owned a rowboat, he would charge money of Confederate soldiers going across the river from Kentucky, I think it was over to Ohio. Well, that's a contract. I'm paying you some money for some service. So you begin to see how deeply involved African Americans and Black citizens, and even in the slave times, are deeply actually involved in the development of contract law, of property law. And after the slavery times, Black citizens went to court regularly, even though they were not viewed as equal citizens. They went to court as often as white people to resolve church disputes, to get marriage licenses, to get divorced, to settle a will or an estate dispute. Black citizens would go use the courts, everyday rights, as he calls it. It's a remarkable law review, and he wrote that book that I also put there at the bottom, Before the Movement, The Hidden History of Black Civil Rights. Again, it's very, very eye-opening, and I highly recommend both. All right, returning to our main topic here. True or false? A signed letter of intent is a valid and binding employment contract. True or false? No. Dr. Doe shaking her head. She knows it is not. And guess what? That language that states in the statute 20-2-211B that says a signed letter of intent is not a valid and binding employment agreement. Guess what organization made the legislature put that in as an amendment? All right. I'm waiting to hear, oh, it was GAE, and that's a true story. True or false, teachers are entitled to a minimum of 3 days to review their employment contracts before signing and returning. No, that is false. Now, I'll turn your attention to this statute 20-2-942. Now, that is possible that law was waived. Now, that law, the 942, says you get 10 days to review your contract. So when your contract comes out, if you aren't told how long you have to review it, ask. Put it in writing, send an email. How long, what is my review period? The local Board of Education may have a policy on it. I've never seen one of 3 days. I've seen them of 10 or less, but that's only if they've waived 20-2-942. So you should use that time to review your contract, even though you know you're going to sign it. You should use your right. It's like that open records law where you're going to ask for your personnel file. The rights are nice, but if we don't use them, they're just going to gather dust on the shelf. Some important dates. Contracts must be offered or else by May 15th. If they are not offered by May 15th, then by operation of law, magic, you have a contract for next year. Then what happens? May 15th, then what happens? You have until June 1st to resign, not later than June 1st. So commonly asked questions about contracts. Always read them. Yeah, good idea to read them. Good idea to read them. Third bullet there, that's an interesting one. That's been on the books a while. Georgia law requires contracts shall be complete in all terms, including the amount of compensation. Well, that amount of compensation, let me tell you, that's a sore spot, because contracts are offered earlier and earlier at a time when local boards have not adopted their budgets for the next school year. So instead of saying, Mike McGonigal is going to earn his salary for the 25-26 school year is going to be $45,610.89, it won't have a numerical amount in it because the board hasn't adopted its budget. It's going to say Mike McGonigal is entitled to a salary based on the local salary schedule, the number of years he has worked, and his certificate level, whatever that might be. But it's not going to have a numerical amount. But it is your right. Once the board sets its budget for next year, you better go back and say, I want to know exactly what my salary is. And it is your right to ask that. And there should be no pushback from that whatsoever. Here's where many of the questions come from. How do I get out of my contract? Well, there's two ways, really. A resignation is a unilateral act. No one's pointing a gun to your head to say you cannot resign. You can resign at any time. Just know if you do, there are some serious consequences, mainly being that you will be reported to Professional Standards Commission, and they will likely recommend a sanction. And we better have some very good facts as to why you just walked out one day resigning from the school district. And those types of fact scenarios are rare. The other way to get out of my contract is through a release. A release is a grant. I don't have a right to a release from my contract. It must be granted to me from the superintendent. And so what comes into play in a release and the burden that you have, the Professional Standards Commission holds this over your head saying, should an educator leave the school system without obtaining a release, the commission may suspend your certificate for 90 work days for breach of contract. Now, here's what the breach of contract says in the Code of Ethics. It's when we fail to honor a signed agreement by resigning in a manner that does not meet the guidelines established by the PSC. Now, the guidelines I don't know if I can, I guess I can't highlight that, but the guidelines are available on the PSC website. They're not that easy to find. I'm not saying that's intentional, but here's the step-by-step guide that you can get all the guidelines as to what they use to determine whether or not you are in breach of contract if you do not obtain a release. You go to the gapsc.com. At the top of the page, there are tabs. You select the ethics tab, and then you go to the resources link, and you click the resources link, and in the resources, you'll scroll to where you find the guidelines for breach of contract. So, common problems, they would say, yeah, Mike, well, we're happy to release you, but we'll only do so when we find a suitable replacement. And if that happens after June 1st, again, that's another magic date, it's going to be tough. It's going to be tough. How long do I have to wait until they find a suitable replacement? There's no answer. There's no answer for that. Through our UniServe directors, we can advocate, and we find good success even after June 1 to release that educator. But after June 1, trying to get a release becomes much more difficult. The other thing to keep in mind, I tell everyone who calls with these situations after June 1, does the district that is offering you a job, will they accept your unilateral resignation, or are they going to insist on a release from the district that you're under contract with? That's in between a rock and a hard place. And again, there's no great answer here. There's no great answer. Once you sign that contract, you're obligated to fulfill it up until June 1st. After June 1st, becomes extremely difficult to get that release. Well, So what we've done in the area of contracts, though, however, is this whole notion of liquidated damages. And some of you might go, what's that? Some of you know very well what I'm talking about. I'm looking at a member right now who knows very well what that is. Liquidated damages, it means that even if I release you from your contract, I'm going to take money out of your final paycheck. And they did that in Griffin Spalding a few years ago. Nikita Jones and Cheryl Clark, they took $750 from their paycheck. Cheryl Clark got a promotional position, and under normal circumstances, you're good to go. They release you, and there's no point in deducting liquidated damages to replace her. And Nikita Jones had a disabled child, and she provided the district medical documentation that it was necessary due to the medication and the changes in the medication for her child that she needed to be work at a school closer to her home. Again, Griffin Spalding, they said, great, but we're deducting $750 from your paycheck to penalize them. And that's the difference. Liquidated damages on one side of the coin is the purpose of it is to provide the employer with replacement costs, the cost to the district to replace you as a teacher. That's the legal side of it. The flip side of liquidated damages, as we demonstrated here, it's a punitive measure. It's a punishment measure. You're punishing these educators I mean, Miss Jones had a disabled child. I mean, but they were off base. So we got them their money back. But the intriguing thing about this case, though, which, I mean, you kind of shake your head, but I kind of love in a way. We filed this lawsuit on behalf of Miss Jones and Miss Clark. Griffin Spalding said, threatened to eliminate payroll dues deduction because we had declared war on the district, and the lawsuit was deemed not professional. So they got upset and threatened to eliminate our payroll deduction. The NEA, our parent organization, jumped on board, and we filed a federal lawsuit on the violation of free speech and associational rights because they were singling GAE out to eliminate our payroll deduction, but keeping other organizations' payroll dues deductions in place. And, you know, quite frankly, lawsuits are not pleasant, but it's not a matter of being professional or not professional. We're standing up for your rights. That's all that amounts to. Well, that settled rather quickly. So this is the other one where we this is our first, I'd call it a landmark case, where we sued the DeKalb School District. Our two members, Jacob Bettis, Leslie Hine, they resigned before June 1. We had excellent facts before June 1, and they still deducted liquidated damages from their paycheck. Well, long story short, the judge in that case found a jury question as to whether or not that $750 truly represented replacement costs. And at the time, Michael Thurman was an interim superintendent there, and under sworn oath, you know, you love Michael Thurman, but under sworn oath, he couldn't say where that figure came from. So that sounds irrational. It sounds like they made it up out of thin air, which is exactly what happened. And we ended up winning $110,000 in a court-administered fund so that everybody that had their liquidated damages taken out of their 17-18 school year contract got it back. And right at the bottom, I added this in today as well. This law school, it is a law school. It's written by Anne Blankenship Knox. She's was an educator professor at Georgia State, and she learned about our lawsuit because at GA we publicize our wins, and she learned of that, and she wrote a really good law review article. Penalty or damages, are there limits to liquidated damages in teacher employment contracts? Florida A&M University Law Review. You should, you know, a lot of other affiliates have filed these suits over the years and lost, or they don't even attempt them because they figure we're going to lose. Why should we waste our resources? You should be proud of GAE. We're one of the few affiliates that have actually sued and actually won significant damages against school districts, and a law review article was written all about it. So Google that, read it, become educated. So in conclusion, we're stronger together. Legal Services is there to support you, and thank you for your membership. And if you're not a member, then please join. And that should be, is that it, Sharon? I ended the slideshow. Whoop.
Yes, Mike, I want to thank you for giving our members that valuable information. They really needed to hear that. And I want to thank those of you who joined us for this Rights at Night session. I want to remind you of some GAE sponsored events that are coming up. On Saturday morning, we have a day of action. On October 1st, we will have a watch party in Augusta, Georgia. That is also sponsored in conjunction with the local association in Augusta. And we have our fall conference coming up October 19th and 20th. And then it takes us into 2025. Don't forget our GAE Day at the Capitol in February of 2025. If you need information about any of these events, please contact Lisa Morgan, our GAE president, at lisa.morgan@gae.org. And again, thank you all for joining us tonight. Good night.